The reading sample here discussed some of the empirical findings on torture, mostly from an international relations standpoint, but this presentation also discusses the work of theoretical logic and philosophy as well as psychology. The main purpose of the findings, in addition to increasing our knowledge of the use of the methods of torture and their impacts, is to illustrate some of the social science methods that are employed to create scientific findings. At this stage, it is not extremely important that you understand or can execute these methods, although you will learn a lot about how social science research is conducted by paying close attention to the methods section of the Conrad and Moore piece, which is coming up first. Conrad and Moore note that torture is probably the most commonly violated human right in the period under study, with an average of 78% of governments using torture. The purpose of their study is to determine when states cease to approve of methods of torture, noting that democratic institutions have empirically been shown to reduce repression, but only where there is no violent dissent. Their research investigates which democratic institutions might have the ability to curb state-sanctioned torture, providing a bit of background on other findings that judicial systems, civil society, and campaigns by NGOs are suggested variables of importance. Their research focuses on the role that executive institutions, specifically the distribution or concentration of power held by the executive, have in permitting torture or stopping it. They refer to the principal-agent approach, which is a specific model of bureaucratic behavior wherein the responsible party for carrying out a task, like governing, delegates it to another person or group of people who then commits the actual act. The principal-agent problem occurs when the agent acts on behalf of the principal in a way that is not sanctioned by the principal. So the state and torture scenario, because torture is most often used to extract information, both the principal, the executive or the state, and the agent, who are the jailers or interrogators, have a similar interest in this information. Whether or not the state creates incentives to use torture should have a direct bearing on the use of torture, in other words. Because the authors recognize that a principal-agent problem could occur if the jailers and interrogators believe that torture does work and should be permitted, while the state, the principal, disallows it, there must be incentives used to prevent torture. Their question relates to when incentives are likely to occur. When, in other words, is an executive likely to be held responsible for those actions, and when then are they likely to prohibit torture and create measures to eliminate it? They dedicate a significant amount of space to explaining how violent dissent can have an impact of mitigating the impact of democratic institutions, since governments will often resort to torture when faced with an existential threat. The authors recount the signing of the Convention Against Torture in 1984. During the 19th and 20th centuries, there was a decline of torture as an accepted legal procedure, and today virtually every country has outlawed the practice, although torture has far from disappeared. When democratic countries first began to outlaw torture, the UK, France, and the US innovated non-lethal, scarless torture. The new techniques allowed for plausible deniability of state executives, which created uncertainty over verbal testimony without any physical evidence. In spite of this plausible deniability, Amnesty International found from 1997 to 2000 that over 150 countries received credible reports of state agent torture. The literature on terminating torture is small, but existing studies indicate re-education and training programs, along with accountability mechanisms, are important necessities. The European Convention for the Prevention of Torture has been mildly successful, and brief case studies have explained the institutions of democracy that have functioned. Institutions, for example, that initiate reforms, public opinion that mobilizes for reforms, and also domestic and international NGOs can sometimes play an important role in this process. This piece builds on those studies by producing in other words, a large number of observations research that focuses on agency relations between executives, legislatures, judiciaries, and jailers and interrogators who decide to torture or not. In explaining the principal-agent problem in more detail, they essentially outline that as long as the principal and the agent agree on terms related to torture, there is no, quote, problem. But they also recount that there can be a conflict between the state, who has an incentive to not permit torture, but the jailer and interrogator does have an incentive to torture, and this depends on institutional norms and mechanisms for accountability. In other words, they explain how torture can continue in spite of legal prohibitions against it. The authors then continue to discuss ways in which institutions might incentivize different actors in the institutions to take actions to try to change the practices of jailers and interrogators. They posit that executives may reduce the use of torture by increasing the costs associated with it. Executives facing risk to tenure in office can enact ex ante or ex post controls on supervision and interrogation. Ex ante controls include implementing institutions and training programs to prevent violations, while ex post controls include monitoring work of jailers and interrogators. Since there is no cross-national information for which countries implement which types of rules, they identify liberal democratic institutions, criminal justice systems, and NGO activities as most likely to lead to the adoption of those programs. They also include popular suffrage, free press as important variables that motivate leaders to limit discretion by the agents when getting information from detainees. The authors distinguish between three liberal institutions: voice, freedom of expression, and veto, and these form the basis for their hypotheses. The voice and freedom of expression elements of democracy increase the likelihood that executives will try to create institutions that limit torture. So, where a press might report on state-sponsored torture and result in the voice option, or the vote. But this is especially true in competitive elections. So this means that Democratic leaders have to pay attention to what is being said about them. However, there are other institutions like the veto, which might actually give actors in government incentive to ignore directives because power is more dispersed and does not directly reflect back on the executives. Thus, they have four major hypotheses. Number one, the presence of competitive elections within a state is positively associated with the likelihood of that state terminating torture. 2, higher levels of freedom of expression within a state are positively associated with the likelihood of that state terminating torture. 3, larger numbers of institutional and partisan veto players in a state are negatively associated with the likelihood of that state terminating torture. And 4, the relationships between voice and torture termination and freedom of expression and torture termination are attenuated by violent dissent. Their period of study is from 1981 to 1999 and covers all countries. They decided to cut off their research prior to the 9/11 era in case those years increase tremendously the use of torture and would bias their results. Their unit of analysis is torture spells, a sequence of years in which agents of the state committed at least one reported act of torture. They also discuss the various ways that they measure their variables. Most significantly, they measured torture from the CIRI Human Rights Database, which comes from Amnesty International and U.S. State Department reports. They also measure violent dissent using the Correlates of War Project. They code countries' institutions according to their free elections, freedom of expression, and veto using POLCON 5 measures from the Political Constraints Project. They measure the type of judicial system by coding the countries as civil, which we also know as code law or common law. And this is a proxy measure that is to capture which type of ex ante or ex post type of restrictions are kept by the system. They compile this data and conduct a survival regression model. Basically, this model accounts for the idea that effects may take more than 1 year to occur or might decrease or increase in intensity over time. Their database includes 3,587 observations, include 146 countries, and 284 spells of torture. However, they also comment that this is certainly an undercount, which actually gives credence to their study since undercounts only provide a conservative estimate, and this can bias your findings to read no relationship or null when there actually is a relationship. While this sounds like a negative thing, this means that if they find a relationship, then that relationship is likely to be quite strong. Their regression models confirm their hypotheses, showing that competitive elections, free press, and freedom of expression increase chances that states will try to curb torture, while veto powers, threats to the state, and civil law are likely to decrease the chances that states will try to curb torture. Code law or civil law systems are significantly less likely to end torture. Most significantly, they found that the effect of violent dissent on termination of torture was more severe than they expected, but that when violent dissent stops, democratic institutions matter. Increases in voice and freedom increase the likelihood that states terminate torture. When state power is checked by the people, officials are more likely to implement training programs to stop the torture, while checks on executive authority serve to uphold the status quo, which limits the likelihood of ending torture. The article that deconstructs the ticking time bomb argument spends a little time identifying the legal instruments that are relevant to the act of torture, and then take issue with recent literature that denounces torture as a basic rule while allowing for exceptions to the rule under extreme circumstances. This is known as the rule and exception argument, and conjures similar dilemmas as the trolley dilemma, wherein a person must decide whether to kill one person in order to save many. Similar justifications have been applied to torturing terrorists as a means of satisfying the lesser of two evils. If torture provides the last remaining chance to save innocent lives in imminent peril, then it is justified. Different versions of the argument exist, but the common elements include the lives of a large number of civilians are in danger, the catastrophe is imminent, the time is of the essence, and a terrorist who holds information that could prevent this catastrophe has been captured. The authors argue that the ticking time bomb argument cannot be used to justify torture. The use of terroristic torture or interrogational torture are important distinctions, they argue, as they are concerned largely with the interrogational torture question. They also distinguish between backward-looking and forward-looking interrogational torture. Backward-looking is to extract confessions, while forward-looking interrogational torture hopes that a captive will reveal plots for the future. They point out that interrogational torture that is forward-looking is usually seen as the only kind that is legitimate. They argue that the deductive fallacy is in play. This is a fallacy that a certain argument infers invalid conclusions from certain premises, either because the conclusions rest on a different set of premises or the premises don't support the conclusion. So in this case, premise 1 is that a terrorist is captured. Premise 2 is that if the terrorist is tortured, he or she will reveal information regarding the location of a primed bomb before the bomb detonates. Therefore, conclusion 1, the terrorist ought to be tortured. Therefore, conclusion 2, the information regarding the location of the primed bomb is retrieved. And therefore, conclusion 3, the bomb is found and disconnected before it detonates. Two problems exist. First is that conclusions 1, 2, and 3 do not follow from premises 1 and 2 without invisible premises also in place. The second problem is that the premises from which the argument deduces its conclusions are illegitimate, being empirically questionable. Intelligence, in other words, is never infallible. There is no guarantee that the suspects captured are the terrorists and that they have the information even if they are. Second, torture is not guaranteed to work, and little evidence exists that torture works quickly. The extreme urgency of the ticking time bomb argument works against the actuality of torture interrogation, which takes a degradation of the subject's resistance over time, not within minutes or hours. Finally, there is no proof that information revealed under these circumstances is actually correct. Because torture increases psychological and physiological results in different people, it is hard to answer empirically, but evidence indicates that tortured confessions are often false. So it is reasonable to assume that terrorists, too, might also give false information. The authors also argue that the appeal of the ticking time bomb argument depends on what they call a consequentialist intuition, where the cost of allowing the practice is counterbalanced and outweighed by the gains of that practice. They believe this ultimately fails because it ignores the larger social consequences of state-sponsored torture. They argue that the empirical evidence suggests that institutionalizing torture interrogation of terrorists has a detrimental consequence for civil, military, and legal institutions, making the cost higher than the benefits. Devastating social institutions can have long-lived consequences for democracy. They point out several institutions whose ethics and integrity are damaged by being involved in the scheme of torture, including medical personnel who monitor prisoners being interrogated, the use of the scientific method to learn about the most effective interrogation techniques, the police, whose task is to determine whether to interrogate a civilian or a terrorist and hope that they always make the right distinction. Military organizations. This military organization can be disrupted by pro-torture and anti-torture factions within the establishment. The legal establishment itself, which in a democratic country rests on the rights of the accused and presumption of innocence. Finally, the practice could serve to degrade the quality of democracy itself if the Fifth and 14th Amendments are routinely dismissed by judges and those who claim to be the representatives of the rule of law. As they note, while the ticking time bomb argument presents a very narrow set of circumstances that have time as the major component, torture interrogation takes long preparation and coordination, and ultimately corruption of many key social institutions. The principal parties that are supposedly helped by the interrogation are the very ones who stand to experience harm from these practices. A much grander moral theory, they argue, is necessary because the simplistic harm of the terrorist versus harm to the intended victims is not sufficient to explain what happens when a person is tortured by the state. The last empirical piece we look at relates to different forms of torture experienced by refugees in the United States and any psychological problems that are correlated to these forms of torture. After briefly reviewing the literature and findings on types of torture and their trauma factors, they present findings to further their existing literature by using larger and more diverse sample size. They also seek to connect these experiences to a broader range of psychological symptoms. Their findings come from statistical analyses of semi-structured interview data taken from 325 patients between the ages of 18 and 72, mainly from Africa and Asia. The participants had been part of the Bellevue Hospital New York University program for survivors of torture, established in 1995. The authors present their findings in Table 1. They examined scores on the post-traumatic stress syndrome symptom scale as well as depression and anxiety scales to determine whether there was a differential psychological symptom response based on torture experiences, and they found that there is. They find that rape and sexual assault is significantly correlated with all three of the symptom distress measures, anxiety, depression, and PTSD. The important contribution made by this piece is the attempt to connect psychological trauma with physical and psychological torture among refugees. The experiences of refugees are important to the topic of torture as they recall one reason why many seek asylum. As states receive and treat the externally displaced, the psychological challenges present policy questions related to refugees and healthcare as well.